Good morning and welcome to today's building audio webinar. The topic today is the JCT 2016 edition of contracts. My name is David Blackman. I am a features writer for Building Magazine, and I'm your chair for today. And we have a great panel today. We have John Riches, Arbitrator and Adjudicator at Henry Cooper Consultants, also Vice Chair of the JCT Drafting Subcommittee, Ben Patton, Partner at Ashurst LLP and a member of the same subcommittee. But kicking off, we have Victoria Peckett, Partner at Construction at CMS McKenna, Cameron McKenna LLP and Chair of the JCT Drafting Subcommittee. Before we do, though, a few housekeeping points. If you want to... After a series of short presentations, we'll have questions from the. We'll be looking for questions. Any questions which don't get answered today, they will be answered, or actually during the webinar, they'll be answered after the event. But in the meantime, I'd like to kick off with Victoria to do the first presentation. Victoria.
Thank you very much, David, and hello to everyone. Just to give you a heads up of the direction of travel, so today I'm going to kick off with an overview of some of the key themes behind the changes in JCT 2016. Once I've done that, I'm going to hand over to John Riches to talk about revisions. John will then hand over to Ben Patton to talk about third-party rights and warranties, bonds and guarantees, and the insurance provisions. And then back to me at the end of that, and I'll talk about BIM provisions, the public procurement amendments that we've made, and a couple of other tweaks made in JCT 2016. And as David said, opportunity for questions at the end. So kicking off with the overview then, let's start by just touching on a couple of reasons behind the changes in JCT 2016. There are three main reasons for those changes. Firstly, there have been some changes to legislation that needed to be reflected in the new contracts. Secondly, there are areas where we felt it appropriate to make updates to reflect current market practice. And thirdly, there are areas that you'll have seen if you've looked at the new contracts where we've tried to streamline the drafting where we can to make the contracts as user-friendly as we possibly can. So looking at some of those areas of change then, and again giving you those themes rather than any detail at this stage. First of all, we have payment changes. Some of those changes will be familiar to you if you're familiar with the public sector supplement that's been in existence for a few years now. So JCT decided to incorporate the principles included in the public sector supplement dealing with fair payment. But we've also taken the opportunity to simplify the clauses, and John will talk in a bit more detail about that in a few moments. Similarly, insurance was another area where JCT looked at it and decided that we could simplify and rationalize some of the drafting. And you'll also see that there are some changes to the Option C regime, and Ben will talk about that. To reflect market practice, we've added the option of having bond and guarantee clauses, so we've got operative clauses there. We've also made changes to the contract particulars to reflect market practice in relation to the procurement of collateral, warranties and third-party rights. And we've changed the subcontracts to allow for subcontract third-party rights as well. We also have made changes to incorporate the provisions that were in the public sector supplement to deal with BIM. We've made CDM changes. We've made changes to deal with the Public Contract Regulations 2015. And as I say, there are a couple of other tweaks to make consolidations to the drafting or to update the drafting, again, to streamline it as far as we can. Now, in terms of the publication system, what you have already are the suites of contracts for the standard building contract, the minor works contracts, and the design and build contract, and updated forms of subcontract collateral warranties. The intermediate suite is due to be released next month, and the next batch will follow in the spring. So that's pretty much what I was going to say by way of an overview. So it's now going to be over to John to talk about payment.
Good morning. What we did in JCT was, and we quite often do this with whole sections, is hive off into a specialist group, which we call the Payment Review Working Group, the whole of the payment provisions, to see whether we could firstly simplify the whole process. And if any of you have read many of the court cases running around the Local Democracy, Economic and Development and Construction Act, you'll see why we wanted to simplify things. And we decided if we could possibly do it, we needed to make the provisions of that act more user-friendly when they found their way into our contract. In addition, we decided to incorporate the fair payment principles throughout the supply chain, which means we were conducting a balancing act between the Construction Act and fair payment to try and get the whole thing to work. Quite a difficult exercise when it comes to timings, linked timings, and provisions on notices and the like. And finally, we decided to bring more certainty to payment dates and to link assessment dates down the supply chain, which follows fair payment. So it was a real balancing act, really, to get the whole thing to try and work. What we decided to do, oddly, for JCT, because we don't often do this, is throw the lot out and start again, and we didn't entirely throw it out. What we did was reorder first. So we've changed the logic of the contract to follow the payment process through interims to final account, which is the way the industry worked, and all of us agreed that that was the best way to present payment provisions. We've consolidated the notice provisions of the Construction Act to cut out unnecessary verbiage and duplication, and I commend the people who draft the Construction Act to look at our version. Our version is much sleeker, works much better, and covers the same ground without all of the repetition in the Construction Act. So when people say JCT is too long, in terms of what we've done, it's much shorter than the legislation, which is the important point. We've linked the payment dates through in our subcontracts and sub-subcontracts, and we've simplified the calculation of payment dates. And what we've done on payment dates is grasp the nettle, as it were, and invited the parties who fill in the contract particulars to put a date in for the first interim payment, and then all other interim payments follow that date. There's no calculation in doing it, straightforward. If the parties choose to leave that box blank in the form, the first payment date is 1 month after the date of possession. The date of possession, if you start leaving those sort of boxes blank, you're in trouble with these contracts. You must fill the boxes in. Thereafter, we hope that if you follow our payment section through in sequence, you should be able to crack all of the nuances of payment under the Construction Act and fair payment from what we have done. I commend it to you. Thank you. Over to Ben.
Thanks, John. Well, my name's Ben Patton. I'm a partner in the construction group at Ashurst and a member of the JCT drafting subcommittee. And as Victoria said, I'm going to cover 3 areas which we've seen change in the new JCT 2016 editions. Firstly, third-party rights and collateral warranties, moving on to performance bonds and guarantees, and finally touching on insurance provisions. So turning to the first of those, in terms of third-party rights and collateral warranties, there are a few changes to these provisions that I wanted to just highlight today. There is now something called rights particulars in the contracts. The main contract particulars are no longer divided into 2 parts in the D&B form, the standard form, and when it comes to intermediate form. A format change is that the old Part 2, which set out the detailed requirements relating to third-party rights and collateral warranties, has been deleted. It's been replaced by a new definition of rights particulars, which in turn is referred to in the body of both the main and subcontract particulars. Now, the rights particulars are intended to be a separate document that will be prepared by the employer and set out the requirements for third-party rights and or collateral warranties from the contractor and from subcontractors. Now, Clause 7 of the JCT standard building contract, design and build contract, and when it's published, the intermediate forms, together with Clause 2 of the standard building subcontract and the D&B subcontract, have amended throughout to refer to rights particulars or subcontract rights particulars as applicable. Now, those clauses that I've mentioned, 7 in the main contracts and 2 in the subcontracts, provide that as an alternative to collateral warranties, subcontractors may be required to give third-party rights, and therefore, as you would expect, consequential provisions are therefore included regarding the contractors and the subcontractors' ability to amend the forms of third-party rights or certain provisions in the underlying contracts themselves once such rights have vested in a beneficiary. So if you look at clauses 7A, 7B and 7E in the standard and D&B contracts and clause 2.27 in the subcontracts, for example, you can see what I mean. Now, the rights particulars themselves may be in whatever format that the employer deems appropriate. However, model forms for those rights particulars at both main contract and subcontract level are included in the accompanying JCT guides and are also available on the JCT website. So, under the 2011 suite, of course, only collateral warranties from subcontractors are envisaged, and if the parties actually wanted subcontractor third-party rights, then these would have to be provided for in a schedule of amendments. Now, the decision by the JCT in the new 2016 editions to extend the option for third-party rights in the alternative to collateral warranties so that it applies to subcontractors in all the standard building contract forms, design and build forms, it's a useful amendment and one that I do suspect will prove popular with employers and contractors alike. In practice, I think we probably all recognise that subcontractor warranties can be a bit of a challenge to obtain. For example, as unlike some other parties on a project, then subcontractors may be engaged as the work progresses, and provision of collateral warranties, which of course require execution by the subcontractor, can at times be overlooked or perhaps sought only once the subcontractor has left site. I think by providing for third-party rights, which can be invoked simply by serving a notice on the party giving those rights, these difficulties, I think, can be significantly reduced. Now, getting the vesting of TPR's right is obviously critical to their successful operation, and so perhaps this new approach may also reduce the risk of third-party rights not being properly incorporated into subcontracts, where perhaps in the past this was achieved by bespoke amendments stipulated at main contract level, but perhaps not always properly stepped down into the subcontracts themselves. In terms of the actual forms of main contractor and subcontractor third-party rights, those from the main contractor are still contained in Schedule 5 in the standard building contract and in the design and build contract. Schedule 5 continues to be split into two parts. The Part 1 again relates to third-party rights from the contractor to purchasers and tenants, and Part 2 concerns third-party rights from the contractor to a funder. The new forms of third-party rights from subcontractors are now set out in Schedule 6 of the subcontracts. An amendment to the forms of third-party rights, which I think is likely to attract particular interest when using the design and build contract, is the addition at Schedule 5 of a net contribution clause in Part 1 and in Part 2. Now, this limits the contractor's liability in the event that the consultants, a new definition for these purposes, which includes the employer's agent and any design consultants retained by the employer, are also responsible for design defects. And this approach is reflected in the forms of collateral warranty too. Now, of course, previously, net contribution clauses were not contained in D&B CPRs, and the JCT recommended not applying them in their standard form collateral warranties when using them with the design and build contract. Now, the rationale behind adding them now is the JCT considers that under design and build, there are specific and limited circumstances where the employer's consultants could be held jointly liable with the contractor in respect of a design defect, particularly as under unamended clause 2.11 in the D&B form, subject to limited exceptions, the employer retains responsibility for the contents of the employer's requirements. Now, the forms of third-party rights in the subcontracts also include equivalent net contribution wording. In addition, the existing net contribution provisions in the forms of third-party rights provided for under the standard building contracts have been adapted to reflect effectively the same approach to net contribution for consistency. Now, whilst it may be said that net contribution clauses have become more commonplace, not all third parties, of course, by any means will readily agree to them, and it is likely, in my view, that funders as well as purchasers and tenants, for example, will continue to resist them on the basis they run counter to a general concept that in a design and build context, the contractor has overarching responsibility for design. But in relation to professional indemnity insurance, the terms of the JCT collateral warranties and third-party rights have been brought into line so that in a D&B context, or if there is a contractor's designed portion and the contract requires the contractor to take out and maintain professional indemnity insurance, the purchasers, tenants or funder will automatically receive an undertaking now from the contractor or subcontractor in relation to such insurance, and that will be in the same terms as those given to the employer under the main contract, or the main contractor under the subcontract, in fact. In relation to subcontractors, however, it remains, though, up to the employer, of course, to specify the nature of the third-party rights, and therefore it is necessary for the employer to specify in the rights particulars, as they're now called, the levels of PI cover, or, where appropriate, product liability cover, that the contractor is to then require from relevant categories of subcontractor under their respective subcontracts. It should be noted that under clause 7.4 of the main contracts, or 2.26 of the subcontracts, the default position in relation to a failure to specify whether rights are granted as third-party rights or by collateral warranty is now that the decision as to the mode of grant rests with the contractor or the subcontractor and not the employer. Now, turning to bonds and guarantees, as Victoria said, one of the other areas that the JCT have amended the 2016 editions to reflect market practice. Of course, the 2011 suite did not contain a requirement for the contractor to provide either a parent company guarantee or a performance bond. And it was therefore left to the parties to amend the contract to make provision for security documentation of that type. I do think it is fair to say now that it's widely considered to be market practice to obtain such security documentation, and that's where the 2016 editions, the standard building contract, D&B form, and as you'll see the intermediate form, they all do contain requirements for either or both of these, which will be seen as a welcome addition by many, I suspect. An appropriate entry will just need to be made against Section 7 in the contract particulars, and the new enabling provisions themselves are contained in Section 7 of the contracts. Previously, of course, Section 7 only dealt with assignment, third-party rights, and collateral warranties. Model forms for either type of security documentation, the guarantee or the bond, are not provided, and it's up to the parties to identify and then agree suitable forms and then append them to the contract. Now, the final area that I wanted to touch on was insurance, So what's changed there? Well, as Victoria said, generally there's been a simplification and a rationalisation, and then option C regime has changed as well. So on the general point, what the insurance clauses have sort of had done to them is that they've been simplified and consolidated across the board to move common provisions from the schedules into the body of the contract, or provisions that were perhaps previously spread around a little bit have been consolidated. And if you look at section 6 of the design and build form or the standard building contract, you'll see what I mean. In terms of that simplification and consolidation, I'd like to draw out just 3 or 4 of those by way of example to show what they include. Now, clause 6.7.2 now sets out the period of insurance for each of the insurance options. Clause 6.12 contains all of the provisions relating to providing evidence of insurance. So if a party reasonably requires evidence, the other party must provide it within 7 days, failing which the party requesting the evidence is entitled to assume that there's been a default in insuring. Clause 6.13 consolidates the provisions relating to loss of or damage to executed work and site materials, insurance claims procedures, and the contractor's obligations to reinstate in respect of each of the insurance options. Finally, clause 6.14 contains the provisions relating to loss of or damage to existing structures and the right to terminate, and that was previously set out in option C of Schedule 3. Now, in terms of insurance for the works, there continues to be 3 principal joint names works insurance options set out in Schedule 3. Again, if you look at the D&B form and standard building contract forms, option A remains new buildings all risk insurance of the works by the contractor. Option B remains new buildings all risks insurance of the works by the employer. And option C, insurance by the employer of existing structures and works in or extensions to them. Now, the big change across the 2016 suite is the flexibility that the JCT have now included for how the parties can agree their own insurance arrangements where works are to an existing structure. Now, the default position is effectively as was, broadly the same people insuring the same things for the same periods of time, but the JCT has now included a provision in insurance option C, which has been modified now with a view to enabling alternative solutions through a new, and the definition is C.1 replacement schedule. Now, what does that mean? Well, the idea is that a replacement schedule can be incorporated into the contract without amendments to the conditions themselves in those cases where flexibility is required to arrange satisfactory cover effectively in respect of existing structures. Now, notably, that could be where the employer is a tenant carrying out works to premises perhaps within a large multi-let office building. It's the flexibility to accommodate some of the common insurance issues in relation to fit-out works, to say one floor of a large office building whereby if a specified peril, such as a fire, for instance, was to start due to the works, and that then burn the whole building down, it's precisely that sort of thing that the JCT have sought to provide a mechanism to recognise in the new 2016 suite. In the minor works forms, clause 5.4c now permits insurance of the works and existing structures by what's termed by other means. So if different insurance arrangements are stated in the contract particulars, that is then what applies. So the flexibility to reflect market practice and the challenges that have occurred in relation to how insurance responds and what insurance is in place has been reflected through the documentation in 2016. So the minor works 2 permits, for example, a tenant employer involving their landlord in relation to insurance arrangements in that fit-out scenario, and that's going to be, I think, very, very welcome by the market in terms of the application of insurance and some clarity that's been provided on it. Now, of course, I would just say that drafting any bespoke arrangements, whichever form of contract is used, will still require careful thought and negotiation, together with input from specialist insurance advisors. But the greater flexibility that's now afforded is, I think, a very sensible attempt to address the sorts of issues that have long been a concern for tenants and their contractors, and frankly have also occupied employers' time in seeking to agree the terms of their contracts. I just hand back to Victoria, who I think had a couple more areas that we were going to cover today.
Thanks very much for that, Ben. That's absolutely right. I've got a few of the other provisions to look at now. So let's turn first to BIM. As I mentioned previously, BIM provisions were previously included in the public sector supplement, so the JCT approach may be familiar to some of you. But JCT took the view that building information modelling techniques are gaining more and more importance, obviously driven from government, but they provide clear benefits for clients and the industry as a whole anyway. So JCT took the view that it was sensible to include BIM provisions within its standard terms and conditions and not simply limit it to the public sector supplement. So that is what has happened. Now, of course, any BIM protocol is going to be primarily a technical document, and therefore, on the face of it, at least at this stage, including many detailed provisions in terms and conditions doesn't seem the right way forward. So JCT has taken a high-level approach to the incorporation of BIM. What it's done is to provide that the BIM protocol can be a contract document. The way that's achieved is that if there is a BIM protocol, it's referred to in the contract particulars and completed as appropriate by the parties. Once, of course, it is a contract document, it is then to be complied with. That's in accordance with the existing provisions of the JCT terms and conditions. The one area where it has quite a degree of influence, of course, is in relation to the submission of design information. Of course, JCT, at least in the main forms for DB and standard contracts, has a design submission process. So that's been adapted to reflect the fact that the parties might have agreed a design submission process under the BIM protocol, and that if that's the case, that will apply in place of the usual JCT design submission process. There are also changes made to the communications clauses within Clause 1 and elsewhere to recognise the fact that information may come in via the BIM protocol rather than other mechanisms. The other point to draw your attention to is the change that's been made to the priorities clause within most of the JCT contracts. Those that use JCT a lot will remember that, at least in, for example, JCT Design and Build, the priorities clause is clause 1.3, and the mechanism there is that JCT takes the view that any technical document or any other contract document shouldn't override or modify what's in the Articles of Agreement and the conditions of contract. The JCT takes the view that those have been heavily discussed by all sides of the industry and a satisfactory position has been reached, and therefore that can't be changed by virtue of a technical document. Now, we are also all aware that there are BIM protocols out there that try to give the BIM protocol priority over all other contract conditions. That's not consistent with JCT's approach, so JCT has modified clause 1.3 to make it clear that no matter what any other contract document says, it doesn't override the terms and conditions. The view that JCT has is that there shouldn't really be anything in the protocol that overrides or modifies the terms and conditions anyway, so it shouldn't be an issue that arises in practice, but just in case, there it is, we still have priority for the terms and conditions. That's a little on the BIM protocol then. Another area I was going to touch on was the CDM changes. And again, those of you that work a lot with the JCT contracts will know that previously JCT had published a CDM supplement intended to allow parties to make changes to the 2011 forms to ensure compliance with the 2015 regulations rather than the old 2007 regulations. So if you've been using that supplement for the year or so it's been around, you'll be familiar with what it's done, and none of it will be a surprise because you'll all be familiar with the CDM regulations themselves. So of course what we have is the substitution of a principal designer for a planning supervisor, and in the main consequential amendments to clause 3.16 in JCT-DB, for example, both to reflect the fact that we have our principal designer and also consequential changes because of changes made to the regulations. Okay, so that's BIM and CDM. Let's turn now to the Public Contracts Regulations 2015. So those regulations have been in force since February 2015 and have application where the employer is a contracting authority and awards a public contract in accordance with the rules and definitions set out in those regulations. There are provisions that apply to all such contracts, but there are a certain number of relatively small number of specific aspects of those regulations that JCT looked at and thought, well, contracts need to comply with them if they're being let by contracting authorities who are awarding public contracts. And whilst certain of those rules may apply in any event, the thinking was, well, we should provide for them expressly, because what JCT tries to do is to provide a set of terms and conditions that's complete, rather than leaving parties to rely on provisions that would otherwise be implied by law. So just picking up on 2 or 3 areas there that are of most importance, perhaps. One of those is in relation to payment, and particularly payment periods. The regulations now provide what had previously been guidance and good practice, which is that valid and undisputed invoices ought to be paid within a 30-day period. Now, that's absolutely fine if you use an unamended suite of JCT contracts, because that's what happens, and we'll come back to that later on. But it's also a requirement of the regulations to include obligations to make sure that that those obligations are flowed down through the supply chain. So we've included amendments to make sure that that happens. There are also other provisions that require the contractor to provide basic information on subcontractors. So provisions allowing to obtain those bits of information have been included. There are provisions within the regulations that give the contracting authority the right to insist on the removal of subcontractors where that subcontractor ought to be excluded for the reasons set out in the regulations. So we've allowed for that too. And we've also allowed for the rights of termination in certain circumstances. There are provisions where the contracting authority needs to terminate a contract where, for example, there's been a substantial modification to it, or the contractor should have been originally excluded, or there's been a serious infringement under European law. So we've amended the termination provisions to allow termination of the contractor's employment in those circumstances. So most of those amendments will be found in the supplemental provisions because, of course, they're not going to apply to all contracts let using JCT standard terms. So we felt the best place to put those amendments was in the supplemental conditions. However, the termination provisions are included within Section 8 of the JCT terms, and you need to look there for the relevant provisions dealing with termination that I referred to a few moments ago. In terms of just 1 or 2 other things to draw your attention to, we also have the Freedom of Information Act provisions included in the supplemental provisions. Again, if you are familiar with the public sector supplement, that the drafting is exactly the same. It's been incorporated into the main contract terms as per the supplement. The consents provisions, this was one area where JCT felt that it could rationalise the drafting. Previously, you'll recall that there were quite a few references to consents and approvals that were scattered through the contract and said that they were not to be withheld unreasonably or delayed. That's been rationalised, so if you look at the front end of the terms and conditions of the JCT contracts, it'll be found in Clause 1. Towards the end of Clause 1, you'll find what I'll call an umbrella provision, basically saying that unless provided otherwise, any consent and approval can't be unreasonably withheld or delayed. So just bear in mind that that is there, and it doesn't need to be repeated throughout the contract. That's all I was going to say on those, I'll call them sort of rather ad hoc bits of amendments. So I'm going to hand back to David.
Great. Well, thank you very much for that, Victoria. And John, I think there's a couple of questions come through on payment, which I understand you'd like to pick up.
Yes, I'll do that. There's one which says, will the intermediate form address, just excuse me a sec, the lack of certainty in the 2011 edition relating to the due date of the interim payment immediately following practical completion. And there's another one which says, can you clarify the revised payment process? There's then lots on due dates and everything else, which I'll go through the lot. The key now is we've simplified the start of the process, and what you're required to do in all of our contracts, including the intermediate form, is put in an interim valuation date, because that's the start of everything that we now do. And that ought to be a specific date. If it's not a specific date, by default it's 1 month after the date of possession. And the first interim valuation runs from that date. 7 days after that date becomes the due date. So if day 1 is the interim valuation date, +7, day 8 is the due date for the money, and the due date is a requirement of the Construction Act. So calculating that due date now is very easy. If you can add 7 to 1, you'll always get 8. Thereafter, the payment notice, which is the first notice that's required to be issued, is 5 days after that date. So 8 plus 5 gets you to day 13. There should be a payment notice on that date. And thereafter, and I'll come back to contractors' applications and the PC point shortly, thereafter, after the due date, the payment is due, the final date for payment is due 14 days. So that gets us up to day 27. If you wish to issue a pay less notice, it's 5 days before day 27, which is day 22. And it's that simple now. We've cut out all of the machinations or calculations of dates and left it simple. What we do now after PC is just carry on monthly interim valuations, and we do it in all of the forms, including the intermediate form. The whole thing just carries on monthly, and that's an end of it because it's easier. So that's what we've done on that front. I also just glanced at, I think, a question on loss and expense. Not sure I can answer that immediately, but let's see. What we have done on loss and expense is tried to speed things up a little bit, and for the first time within clause 421.4, we've said within 28 days of receipt of an initial assessment and information and 14 days of each subsequent update of them, the architect, CA or QS shall notify the contractor of the ascertained amount. What we tried to do is to get some commitment in the loss and expense provisions in order to speed up payment, because invariably in practice somebody makes a loss and expense application, nothing happens for months. So we've actually set some times on it now. whether that will work in practice, we will see. The question, I think, goes to is the notice a condition precedent? And what the clause says is the contractor shall notify the architect as soon as the likely effect of a relevant matter on regular progress or the likely nature and extent of any loss and expense arising from a deferment of possession becomes or should have become reasonably apparent. We've actually slimmed down some of the previous wording. And what we don't do in terms of measuring whether a clause is a condition precedent or not, there's no penalty for failure to do that. The bottom line is the process does not trigger until there's a notice. It's as simple as that. So it can't trigger until there's a notice, and it can't trigger until the notification has been accompanied by the documents listed in clause 421.2. So in real terms, until the courts say otherwise, I don't think what we've drafted now amounts to a condition precedent.
Thanks very much, John. And while you've been speaking, we've had another question from James Marcroft. He's asking, as a follow-up, when is a payless notice valued to the date of the notice of the due date?
I'm not sure I understand that. There's a peculiarity in the Construction Act which says that a payless notice is the sum in a payless notice is calculated on the date of the notice, so it doesn't go back to the due date, and that's a peculiarity in 111.3, I think, of the Construction Act, and we've reflected that. And there's good reason for that, because what you can't do is write contracts with more than one due date. And what you're trying to do at the date of the payless notice is take into account everything that's happened subsequent to the payment notice, assuming there was a payment notice. So, for example's sake, if defective work was discovered between the due date and the payless notice date, that's a factor that you would take into account in compiling your payless notice. Some have argued in the industry that you can't add the few weeks' work that's been done in that time. I question that, because I think if you're required to calculate what was due on the date of the payless notice, you're doing a brand new calculation, you're adding some more work in and knocking stuff off. And the net effect is that you'll still pay less, otherwise you wouldn't issue the notice. So I think that's the way it works under the Construction Act. That's what we reflect in our contract.
Great, thanks very much, John. Right, now we are being absolutely flooded with questions now. So, but fear not. If we don't get the chance to, if the panelists don't get the chance to answer your queries today, then everything's all questions will be answered following the webinar. Also, a number of you are asking whether materials will be available. The webinar will be available on demand on the building website from tomorrow, and the slides will be available as well. Right, without any further ado, I'd like to pop on. We've had a number of questions around Option C insurance. Richard Sharps from Dalbergia Consulting is asking, could you explain the key changes to Option C insurance? We've also had a number. Michael Knight from CBA Architects is asking, regarding Option C insurance, where employers cannot gain insurance, are we saying the contractor can now gain insurance with employer as a beneficiary under Option C1? Ben, I gather you'd like to answer these in one go.
Yeah, thanks very much. It's probably worth pulling a few of them together. It's been quite interesting watching the flurry of questions through on Option C. The general theme of them seems to be regarding that Option C. Are there any further guidance notes on how you might customize it, or can you explain the key changes in insurance Option C, and moreover, how does the JCT envisage that the replacement schedule will operate? So I think if you take those reasonably in turn, the DB Guide 2016, I think, has paragraphs 112 to 117. I think they have further guidance on how that how those alternative arrangements might generally be adopted. So it gives a bit more flavour on that side of things. Could you explain the key changes to insurance option C? Well, I think, just to recap, I think the key change really that I'd flag is the flexibility that's now been built in to address the practice in the market. That brings me on to how does the JCT envisage that the C1 replacement schedule will operate? Well, at its simplest, it disapplies, quite simply, paragraph C.1 in Schedule 3. So that would mean that the employer shall otherwise, unless stated in the contract particulars, be the one that maintains the joint names policy in respect of the existing structures. So we're in a scenario whereby that has been disapplied as the base and standard case. So if you follow that through and looking at the questions that have come, not surprisingly, most of them relate to a fit-out context. I think there are two key questions probably to ask back in relation to taking forward how the contract is actually amended, or rather a replacement schedule is populated and operates. The first of those, I would say, is the employer the building owner, and if so, does it have a project or block policy? And in my experience, it often will in that case. I suspect probably what we're talking about here more is, conversely, if the employer is a tenant in that building and it's engaging a fit-out contractor, how can that work? And I think in terms of producing a replacement schedule, it's going to very much turn on the particular facts and circumstances of the project, how the parties want to and can insure it, and what the price of or limitations on those insurance policies are, and the policies themselves. I think if you're looking at perhaps lower value projects, the contractor may there often be able to cover the risk of the loss or the damage to the existing structures, perhaps under its public liability insurance. If you move slightly higher up that scale in terms of project cost and value, you may find you're into a position whereby that tenant employer of that multi-let building that I was talking about, perhaps you're into a slightly more complex regime where you've got different levels of cover that are applying and in relation to the risks that might be identified, and that's probably why you're moving into the position of a replacement schedule that you can tailor to your particular project needs, rather than having to try and amend the provisions of Clause 6 or Schedule 3, Option C, in relation to how you're going to deal with it. The idea is that you can leave the contract really as is and put in place a reflective and reasonably bespoke arrangement, albeit in quite a simple document. I think if you move even higher up that scale and you're into quite high value projects, then that's quite a different position, and you may find there that and again, this would very much depend on the particular insurance arrangements, but you might not be talking about the full reinstatement value at that point, and that's getting really quite bespoke indeed. So one of the other questions that came through, which is slightly linked, just looking at the questions that come through, slightly linked to Option C, is in relation to insurance provisions in the new JCT minor works contract and how that works. Or as I touched on slightly earlier, they have insurance by other means if you apply that option in the contract particulars, which is a very, very simple way, obviously given the nature of the contract, of trying to arrive at the same flexible mechanism whereby the JCT have recognised that it isn't a one-size-fits-all, and actually it's very much going to depend on, as I say, the project, the parties, and the insurance arrangements they want to put in place. While I'm on, I might as well just deal with one other, which was in relation to performance bonds, and the question was, has the standard wording been incorporated into into the contracts in relation to the new provisions. Well, as I think I touched on earlier, the mechanism is there. There is an ability to populate in the contract, particularly certain aspects of either the performance bonds or the parent company guarantees if they're going to be required by way of security. But in terms of the actual security documents themselves, whilst there's a steer on that, as I mentioned, it will be for the parties to the contract to identify if either or both are going to apply, and if the answer is yes to either, then identifying and agreeing a form of that security to append to the contract. That was what I had to say on that, David. I don't know if there's somebody else that's written in with anything that's of interest.
Great, thanks very much, Ben. Unfortunately, we were only able to sort of deal with a fraction of the calls for the questions we've had today. But in the meantime, we've had a question from Paul Walmsley at Hawley, who asks if we have any thoughts on a JCT professional services appointment. Victoria, I gather you'd like to pick this one up.
Hi, yeah. That's just a reminder that there is, in fact, a consultancy agreement already out there, and absolutely right, that's going to be updated in the 2016 suite, and will be part of the batch being published early next year.
Great, thanks very much. John, we have a further question on payments from Neville Simpson, which I gather you'd like to pick up.
It's a good example of whatever we do, somebody will still come up with a good and challenging question. This particular question, and what it asks is, when the final account has been agreed, do you still have to issue zero payment notices until after making good of defects? Well, sorry, the answer is yes, you do, and the reason for that is not a JCT reason, it's the way in which the Construction Act is drafted, because until you reach the point under JCT of final certificate, the process doesn't stop. So unfortunately, if everything was in place and a final certificate could be issued, and for some reason it's not, you need to carry on month in, month out, issuing zero payment notices. So the answer is to reach the point as soon as you can when the final certificate is issued, and then the whole process stops. So that's an unusual circumstance which we didn't draft for. We hope that everything falls into place as per the rest of our contract. Thank you.
Great, thanks very much, John. We've had a couple of questions on BIM, which I gather Victoria would like to address. First of all, we have a question from Jason Carwood at BHP, who asks, is there a provision for reliance on BIM model data being contractual? And the second question is from Martin Ronseret from BSRIA Limited, who asks, is the BIM inclusion into contract made by reference to standards or codes? And if that's the case, which ones, please? Victoria.
Thanks. Okay, so I'm going to do those in reverse order. So the question about what is meant by BIM protocol and what is actually incorporated, JCT's left that for the parties to decide. They can adopt whichever protocol they feel is most appropriate, and that's done by way of filling in the blanks in the contract particulars. So if you've got a BIM protocol you want to use, it's up to you to specify the one you do want to adopt. The question about reliance on BIM model data, I'm going to have a go at answering what I think the question is being asked there. So you'll remember me saying that compliance with the BIM protocol will be required because that is a contract document. That, of course, is really dealing with processes rather than outputs. But when we're talking about model data, then in the same way that if any party relies on, for example, design information provided, then liabilities, obligations and rights in relation to that data currently are unaffected, so they are as they would be if that information had been submitted via any other means.
Great, thanks very much, Victoria. And I'm not going to let you go, I'm afraid. We've also got a question from Hilary Robson at Connecticut Consult. She asks, in relation to new umbrella clause, the new umbrella clause stipulating that consent not to be unnecessarily withheld, what happens in the event that consent is not given in a reasonable timescale?
Okay, so that one, so the contractual obligation is don't unreasonably withhold or delay consent. So if someone unreasonably withholds or delays consent, that on the face of it will be a breach of contract. Most times that is going to be a problem for the contractor who's expecting something to come out of the employer or his team. If there is a breach, then that will be a breach on the part of the employer or his people and will give rise to claims for extension of time and loss and expense. If it's the other way around, then it's going to be a delay, really, causing a delay for which the contractor is responsible, and that will then lead to delay at the end of the project and possible liability for liquidated damages.
Great, thank you. Fast approaching, but I'd just like to pick up a question for Ben. This is a follow-up from your earlier discussion about fit-outs. Paul Smith from ACOM asks, will the new insurance provision relating to fit-out within multi-tenanted building recognise that the fit-out contractor will need to provide cover for the full reinstatement value of the base building?
Thanks very much for that. I think on the new regime, I think it's probably, as I mentioned, in terms of the replacement schedule, something that if you're going to go down that route, you are documenting the position that is there in practice, what can be put in place, and the relevant and respective insurance policies. So that is where I think you would be reflecting what the are that you're able to agree to on any particular project, because obviously it's getting relatively bespoke at that point.
Great, thank you very much. And we have a question from Adesola Lowell from Billing Cost Associates. He asks, what will be the implications if quotation for acceleration is accepted by an employer but contractor is unable to meet up with acceleration, causing further delay? What is the JCT position on this? John, I gather you'd like to pick this one up.
Lovely question, completely off-piste of what we're doing today, but wonderful. The position is, what we're trying to do, and this JCT 2016, is facilitate quotations for variations and for acceleration. So once an acceleration quotation is accepted, that's it. If the contractor fails to meet the acceleration that he's quoted for and the employer has agreed to, there is no loss of that money. The thing has been accepted, and it's simply further delay which should be dealt with by the liquidated and ascertained damages clause, because at the point where he fails to meet the accelerated date, the LAD clause kicks in. So quite difficult on the hoof, that one.
Great. Well, thanks very much. Okay. Yeah. I think we've got one more to come. Question on does a question from Marianne Azar at NPS London. This is probably one for you, Ben. Does option C become applicable if an existing building attached to other buildings has to be demolished and a new building constructed but not abutting to the other buildings?
Wow. That's quite a detailed question to answer within the 30 seconds or so that's remaining. I think probably what I'll say on that one is I'm very happy to pick that up with you separately. I've got your details and I will be in contact to pick that up. Otherwise, I suspect I'll be running over time trying to grapple with the answer to that one, if that's okay.
Okay, well, thanks very much, Ben. Thanks very much, Victoria. Thanks very much, John. As I said at the beginning, this will be on demand from tomorrow. And also, if you do have any other outstanding questions, they'll be answered following the session. All I can say is thank you very much for listening, and I look forward to our next building webinar. Thank you very much. Goodbye.